Nothing stated by Steve Bartlett during the Fight Back with Steve show is intended to be legal advice, and appearing on the show does not create an attorney-client relationship with Steve Bartlett. Before taking legal action, it is advisable to consult with an attorney of your choice. The views and opinions expressed by the callers and guests of the Fight Back with Steve show are solely opinionated by those individuals and are not necessarily the expressions and viewpoints of Steve Bartlett or Talkwat Studios.
I'm Steve Bartlett. Welcome to the Fight Back with Steve Bartlett show. It's my pleasure to be here again. You know what time it is? It's supposed to be 8 o'clock, but as Albert Einstein proved, time is relative. So even though my show is supposed to stream live at 8 o'clock every Monday night, sometimes it takes time for me to set up and appear. So yes, it is about 8:15 and I'm just starting to talk right now, but hey man, what do you expect? Do you expect me to be on time? You know, that's what judges say to me when I go to court. They expect me to be on time, but hey man, this isn't court. I can do whatever I want. So, you know, tough luck if you were staring at your computer just waiting for me to get on so that I can, you know, do my show and entertain you folks on Monday nights at 8 o'clock. But for 15 minutes I was busy doing other things instead of being promptly at, you know, on the air at 8. So I apologize to you. Well, I really don't apologize. I could care less, actually. You know, it doesn't really matter to me whether I'm on at 8 or 9 or 10. But if you're watching and it does upset you, then I feel bad that you were wasting your time staring at your computer without anything else to do except waiting for me to you know, fill your time with my legal brilliance. Actually, I don't know why I'm talking like this tonight. This isn't my normal fight back posture, but I'm kind of punchy. I had a long day today. I was dealing with clients all day. I got court tomorrow morning, and who knows? I'm just being kind of weird tonight, but don't worry about it. The reason I wanted to do my show tonight and what I wanted to talk about is about the media and how the media gets involved in stories and how both sides, the left and the right, they kind of exaggerate things in order to get their own opinion out. And I'm actually calling the people that I'm normally, you know, on the same side with, I'm calling them to the, you know, to say that what they haven't been saying has been exactly truthful. And one of the big stories that's been going on MSNBC, which is a channel that I sympathize with being a liberal, is the story about Trayvon Martin and all the talk hosts on MSNBC, from Chris Matthews and Ed Schultz and Rachel Maddow to Reverend Al Sharpton, have been very upset with what happened with the Trayvon Martin shooting, as they should be. The law in Florida concerning Stand Your Ground is a terrible law, and in my opinion it should be repealed. And George Zimmerman, although I believe the verdict was correct under the law, it really is a shame that he was able to shoot an unarmed boy dead because of a loophole in the Florida statute. But even though I agree with, you know, that assessment that Stand Your Ground is wrong, there's been a false equivalence that's been going on. What they've been trying to do is say that not only is George Zimmerman a racist, but that the whole Florida legislature is racist as well. The court system is racist, and the prosecutors are racist. And what they've been doing in order to prove that there's racism involved is that they're bringing in another case that's been going on in Florida for the last couple of years, and that's the case of Marissa Alexander. And Marissa Alexander is an African-American female who was arrested for firing her gun in front of her husband and his two sons. I don't know if they were adults or if they were minors or not. And even though nobody was hurt or injured, even though She never shot anybody. She went to a jury trial. She tried to argue self-defense. She raised stand your ground as a defense, which is part of the self-defense statute. And the jury convicted her, and she was sentenced to 20 years in Florida State Prison. And so what the people on MSNBC, particularly Al Sharpton, have been arguing is that this is an example of racism, that it's okay to shoot dead a black boy under Stand Your Ground, but here is an African-American woman who doesn't shoot anybody, doesn't hurt anybody, who's the victim of domestic battery by her husband repeatedly, and all she does is hold a gun, doesn't shoot him with it, and she gets 20 years in prison, and therefore the system is racist, and it's not fair that she got 20 years in prison when what she did was less offensive than what George Zimmerman did to Trayvon Martin. Well, that's a false equivalency, and that's what the show's about tonight. I'm going to explore why what happened with Marissa Alexander isn't the same as what happened with Trayvon Martin. The two cases are completely different, and it's sensationalistic to try to claim that because of the fact that she was convicted and George Zimmerman was acquitted, that there's some sort of racism going on. So I'm not an expert on the Marissa Alexander case. A person's considered to be, innocent until proven guilty. And although the jury came back guilty and she was sentenced to 20 years, she filed an appeal, and the appeal came back in her favor, and she is now set for a retrial on the same charges again. Except this time, although she was sentenced to 20 years in prison, the state is letting her know that she can actually get, theoretically, up to 60 years in prison because she has 3 counts that she's facing, 3 counts of the aggravated assault with a firearm, and therefore they can run them back to back to back, which is called consecutive versus concurrent. Concurrent is when sentences run at the same time. Consecutive is when sentences run back to back. And there's a question in the law as if you have 3 counts of aggravated assault with a firearm under the 1020 life statute, whether the judge has to give you consecutive time, meaning 60 years in this case, or whether the judge can give you just 20 years and run all 3 of the cases concurrent at the same time. So even if you're found guilty of all 3 counts of firing a firearm at shooting a firearm at someone, they can still give you 20 years, but they can run the sentences at the same time, so you only get 20 years in prison as opposed to 60 years in prison. There's a question as to the law in the district where that case is, as to whether or not the judge has discretion to give concurrent versus consecutive time. Because of the conflict, the Supreme Court of Florida could eventually decide that down the road, but I digress. Now, here's the deal. I don't know exactly what happened to Marissa Alexander, so I'm just giving my opinion based upon what I've actually heard the evidence is. She may be completely innocent. I don't know. I'm not commenting on whether she's guilty or not. I don't know. I'm just commenting on whether or not, under the law, she's being treated in a way that's unfair because of the fact that she's African American versus other people who have similar type of cases in the state of Florida. So that's what I'm talking about. So I don't want anyone suing me saying I'm slandering her, saying she's guilty of the crime. I don't know. I haven't heard any testimony. I'm just going by what I've read the testimony actually said, what the police reports actually said, and whatnot. So if I make any factual mistakes, I'm just giving my opinion based upon what I've heard. And like, again, I have no idea whether she's guilty or not. But anyway, here's what the people like River and Al Sharpton have been saying actually occurred. And like I said, I don't know whether it's whether it's true or not. But this is the position that they're saying, that she was abused by her husband and had been battered by him, and that he threatened her. And therefore, she took a gun, and although she never had the intention of using it on him, just threatened him with the gun by pulling it out and then firing a warning shot in the air and never shot him. And yet she was found guilty of aggravated assault with a firearm, sentenced to 20 years in prison, and how that's fundamentally unfair. Because why should you be able to shoot somebody like George Zimmerman did, and be acquitted and get nothing by saying stand your ground, but merely pulling the gun and not shooting anybody gets you 20 years in prison. Well, those two cases are different, okay? And the reason why those two cases are different is based upon the facts. Now let's talk about the Marissa Alexander case, because the way that MSNBC tells the story to make it seem as if she's a victim of racism isn't really telling you all the facts of the case that at least I learned about, because I only knew what was said by watching MSNBC as well and other similar type of shows which were saying that she was a victim of racism. But then I started researching and finding out some more facts about the case, which makes it, I'm not saying she's guilty, but what I can say is it doesn't appear as if she's a victim of racism due to the fact that she was found guilty and George Zimmerman wasn't. Okay, now what the facts of the case appear to show, based upon the police reports and what I've read, is that she and her husband were married for about 2 months, but had already split up. They weren't living together anymore. And they had a newborn baby who was in the hospital. I don't know whether the child was sick or whatever, but the baby was in the hospital. So even though they weren't living, even though she wasn't living in the home, she actually drove there one evening and spent the night. Now, when she spent the night, her husband wasn't home, so he wasn't home, but she pulled into the driveway, went to the garage with her car, parked her car there, and actually spent the night there. So I don't know why, I don't know if she was fighting with her husband and was just moved out, or if they had a separation or whatever, but she spent the night. And then the next morning, they had breakfast, and the people who were there were her husband, and he had 2 sons. I don't know how old they were, whether they were minors or whether they were adults. I don't know that, but they were having breakfast together, and she had pictures of the baby that she had on her cell phone, and she gave it allegedly to her husband to take a look at the pictures of the baby. And while he was looking at the cell phone, she went to the bathroom, and the bathroom was located in the master bedroom, so she went into the bedroom, went to use the bathroom while her husband was looking at pictures on the cell phone. Now, the other thing that isn't in dispute is that this guy had a history of violence and had a history of committing domestic violence on his wife. I don't know how often it occurred, but there was a history there. Well, what happened next was, while the husband was looking at the cell phone and looking at the pictures of the baby, he came across some text messages from another guy. And he got all pissed off and started thinking that she's cheating on him and playing games, and questioned whether or not he was really the father, or whether this other guy she was texting was really the father. So he went to follow her into the master bedroom and started confronting her in the bathroom, where he got into an argument with her, where he started yelling and screaming at her about who the guy actually was, who texting her, whether he's really the father, and they're fighting and all that. According to everyone, at least according to the police reports, he wouldn't let her get out of the bathroom. Now, but eventually everyone calmed down, and then he split, went back into the living room, and then she left the bathroom. Okay, but for a while, he was actually allegedly blocking her from getting out of the bathroom. Now let's pause right there. Understand your ground, and I've talked about this before. If a person is threatened with a violent felony, they can use deadly force in order to stop the commission of a deadly felony. And what happened here is, it seems as if he may have been committing the crime of false imprisonment or kidnapping. And I know kidnapping is one of the felonies that if a person is committing against you, you can shoot them dead to stop that from actually occurring. I think false imprisonment may be one as well, even though I don't have the statute in front of me. So right now, if she had the gun in her hand and he was blocking her from being able to leave the bathroom, and he was screaming at her, and she reasonably had fear that he was going to, falsely imprison her or brutally beat her or whatever, then that could be a good reason for her to use stand your ground, if she had the gun with her at that time. And she could probably, if he was kidnapping her by keeping her imprisoned in the bathroom against her will, and she used deadly force, she could probably get away with it. But that's not what actually happened, and this isn't a dispute. He ended up backing down and he ended up leaving, and he went into the living room with the kids. And then she left the bedroom, walked through the living room, past her husband and the kids, and then went out into the garage. And she went into the garage, and she went in the glove compartment in the car, and she got a firearm out. And then she went back inside, at which point she pointed the gun, allegedly, at all three of them. And according to the testimony, her husband and his two sons raised their hands over their head and clearly didn't have anything in their hands. And then she fired a shot. Now, the way it's portrayed on MSNBC is that she fired a warning shot, which makes you think of someone taking a gun and firing it up in the air. But that's not what the testimony appeared to be at trial. What was said at trial was that the shot sailed over his head and barely missed him. So whether she was firing a warning shot versus firing at him and just happened to miss is a big distinction, because shooting at somebody and missing is not the same thing as saying stand back and shooting it up in the air or shooting it somewhere so far away that no one can get hurt. Trying to actually shoot somebody and missing is a crime. It is a very serious crime. That's attempted murder a lot of times. So, if that's what exactly happened, then the jury could come back guilty. If someone pulls a gun and fires a shot and happens to miss, that's not really being, someone who's just doing nothing but holding the gun out of fear. You're actually shooting at somebody that you know isn't armed. And the other difference is she could have left, but instead went into the garage and got the gun. So if she was afraid, why did she go back inside with the gun? Why didn't she leave? Now, she later claimed that the garage was broken and that she couldn't get out of the garage. But, the evidence, according to the police, showed that really wasn't true, that she could have left. Now, that's a question of fact. The jury could decide not to believe her on that. Or maybe she was telling the truth. Maybe she couldn't get out of the garage. But whether the jury believed her or not, it's like any other type of jury trial. The jury can believe whether it's self-defense or not. Just because a person makes a claim that it's self-defense doesn't mean that it's always going to be believed by the jury. Why would she come back? Why would she go out and get a gun, go back inside after everything had calmed down, after her husband had let her out of the bathroom and was in there with the two boys? They raised their hands, they were unarmed, and yet she fired. Wasn't like, I don't believe there was any testimony that he was attacking her and then she fired it in order to stop him from attacking. So this is a similar situation to if in the Trayvon Martin shootings, if while George and Trayvon were having the argument, if George would have then stopped the argument, gone back into his car, gotten the gun out of the car, and then gone out and shot Trayvon Martin, that would have been more similar to what actually occurred in the case involving Marissa Alexander. And under those factual, conditions, it's highly unlikely that George Zimmerman, if he would have gone back into the car to deliberately get the gun after having the confrontation, if he would have been found not guilty under those circumstances. I mean, I wasn't part of the jury, but there's a big difference between actually being in a fight and pulling a gun versus getting into a fight and then, after the fight's over, going back and getting a firearm. Okay? But that's not everything that's occurred. That's not all the evidence that came out. Another reason, there was some other evidence that came out that went to the credibility of the defense. For instance, after this occurred, her husband called 911. She didn't call 911. And so the state was able to make the argument to the jury that a person who doesn't call 911 is a person who committed a crime. They're not the ones who call 911. The other people call 911. The victims call 911. If she was innocent, why didn't she call 911? Now, who knows whether that's true or not, whether or not she committed the crime or not, but the difference is that's a fact that goes to the credibility of the defendant and doesn't necessarily mean that the prosecution itself was based upon racism. You know, if the person fires a gun at somebody and then doesn't call 911, that could show that they have consciousness of guilt. Another thing that happened was that there was a no contact order that was entered by the court, in which just happens all the time in violent crimes, in which once the person's out on bond, they're not allowed to have any contact with the other side. Well, you can always go and ask the court to remove the no contact provision, but the judge makes it very clear that until the no contact provision is taken away, you are to have no contact at all with the other side, with the victim, unless you get a court approval ahead of time. Even if the victim says it's okay, you can come around and we can kiss and make up, you can't be around the victim if the judge says you can't be around the victim. Well, allegedly what happened, and what testimony happened in the trial, was that she violated the no contact provision by actually going back over and having visitation with her husband, and that she then, while she was over there committing a violation of the judge's order to stay away from her husband, who she says she had to pull the gun and defend herself because she was so scared. If she's so scared of him that she was forced to take the firearm and fire it, why would she violate the no contact provision and go over there with him? But not only that, but while she was violating the no contact provision, allegedly, she also committed a battery on her husband at his home. And then when the police did an investigation, according to the police reports, she allegedly lied to the police about even being there. Her first response was, "I wasn't there, I have an alibi." At least that's what they say in the police reports. And then her next position was, okay, well, I was there, but he was beating me with his fists, so I had to hit him back in order to defend myself, which was a change in her story, allegedly. But according to the police reports, when they looked to see if there was any marks or any proof that he committed the battery on her, there wasn't any. So what we have, according to the police reports and the evidence that was put on at trial, was that the judge said that she shouldn't go over there, was not allowed to go over there, and she deliberately went over there anyway, even though she claimed that she was so scared of him that she had to pull the gun in order to defend herself. And while she was over there, she committed a battery on him, lied to the police about it, lied about even being there, and then lied about hitting him, claiming that it was self-defense. Now, that's what the police report says. Now, I don't know if that's true. Maybe she told the truth. Maybe everything she said was totally true and everything that the police said was totally a lie. But that's not what I'm getting at. I'm getting at the fact that the testimony that was said before the jury was that she was somebody who lied, that she was somebody who committed violence on her husband, that she was somebody who wasn't acting as if she was afraid of her husband, but was actually somebody who was going over there in violation of the no contact provisions. So the state attorney was able to successfully argue to the jury. She went back and claimed that she couldn't get out of the garage, which we were able to put on evidence saying wasn't true. She claimed that she was just firing a warning shot, even though the evidence shows that that wasn't true. She just barely missed his head. And also, there was evidence that later her husband lied by contradicting himself. At depositions, her husband basically backed up her story and said that, yeah, I was threatening to kill her. Yeah, she wasn't doing anything wrong. Basically, he recanted what he said on his 911 tapes. And that's very common in domestic cases for a victim to come in and recant and say it never happened. But then he recanted his recantation and said, okay, well, I lied at depositions because she conspired with me to lie, and we came up with a concoction. That's why she was coming over, so she can get me to lie on her behalf and say that it was self-defense when she pulled the gun on me. But I lied because she told me to lie. Okay. So we have that on top of that. We have a person, at least that allegedly went back and got a gun, pointed it at unarmed people, fired it, barely missed them, didn't call 911, violated the no contact provision, committed a battery by violating the no contact provision, lied to law enforcement officer repeatedly about that, and encouraged the witness for the prosecution to commit perjury at deposition. Now, I'm not saying that is true. I wasn't there. I can't vouch for the state's case. But that is a reasonable bit of evidence that could make a jury reject her self-defense claim and come back guilty, which is what the jury actually did. The jury heard all the evidence, and the jury, after hearing all the evidence, came back in less than 30 minutes, less than the time it takes to get a Domino's pizza, and came back guilty. Now, she appealed it, and she won her appeal. Now, she didn't win the appeal because she was able to successfully show that she was a victim of racism or that she was treated poorly because she's an African-American female. She won her appeal because the judge made a mistake when giving the jury instructions to the jury. He basically said that she had the burden to prove beyond all reasonable doubt that she was a victim of battery when she acted in self-defense, when in any criminal case the defendant never has to prove anything. Self-defense, if there's a reasonable doubt as to whether it was self-defense or not, the state has the burden to prove that. Okay? So it came back on that technicality, not because of the fact that she was found to be a victim of racism. So I'm not saying the jury's verdict was correct or wrong or right. I'm just saying just because she's African American is not a reason to say that she is a victim when she allegedly pulled the gun and fired, barely missing her husband when he was unarmed after she went back after having the ability to leave and got the gun. That's what the facts allegedly show, and if that is the truth, then she's not a victim of racism and not a victim of selective prosecution. Now, one argument that could be made is that the sentence was an excessive sentence. And in Florida, which is some of the harshest laws in the country, we have something called 10-20 life. And what happens is, if you commit a crime with a gun, you get 10 years in prison. Okay? Automatically, boom, 10 years, minimum mandatory. Judge has no discretion to go below that. You get 10 years. If you fire the gun, you get 20 years. No discretion. Even if the judge likes you, even if the judge loves you, judge has to give you 20 years that the jury finds that while you were committing a crime with a gun, you fired the gun. And if you hit somebody, then you get life. Okay, that's the 10-20 life statute. Okay? Now, I'm against these mandatory sentencing laws for a lot of reasons. One, it's too harsh, and I don't think in the case that no one ever got shot, the taxpayer should have to pay her for 20 years. I mean, pay 20 years, the bills paying for her food and housing and everything like that. That's just crazy. It's a waste of our taxpayer money. But that's what the law is. The other problem I have with the 10-20 life law is that it violates the domain of the judge. It basically makes the prosecutor, which is the executive branch of the government, in charge of not only the prosecution of the case, but also the sentencing as well. By taking the discretion of a judge to give a proper sentence and giving it complete to the state is acting both as prosecutor and judge. And I think that's wrong, and I think that's unconstitutional. I think that judges should always be the check and balance on the legislature. Legislature writes a law. The judge should have the ability to do what's just, as opposed to just leaving it to the state attorney's office. Now, the state attorney's office is being portrayed as being racist by her being sentenced to 20 years in prison. However, prior to trial, she was offered 3 years. The state agreed to waive the mandatory 20-year prison sentence and offered her 3 years in prison instead. And she rejected it. So that is being very fair. Taking a mandatory sentencing law and saying we will waive that and give you, only 3 years as opposed to 20 years, it's hard to say that the prosecutor in that case is being racist when they're actually doing something which is way below what the Florida legislature says they're supposed to do. So it's really a hard case to say that she's a victim of racism, and that's the equivalence of Trayvon being shot dead. There are two separate laws. One's the stand your ground law, and under that law, anybody has a right to basically shoot someone dead. And I think, under a lot of circumstances, and I think that law allows that to happen. But I don't believe that under the facts of this case, that the equivalency that she is a victim of racism is demonstrated by the facts of the case, at least as presented to the jury. So I'd like to, thank you for joining the show tonight. And remember that when you are faced with injustice, you have three choices. Choice number one, you can ignore it. Choice number two is you can go along. You can go along with it. Or choice number three is you can rise to your feet, put your fist in the air, and fight back, which is what I try to do. And I will see you next week. Thanks a lot. Bye.